Last week in the Ontario Superior Court of Justice Family Court Division, there was an interesting case that came out. I think about a half dozen people have sent it to me and asked for my commentary, so I figured it was something that viewers would be interested in, and this week on Don't Talk TV, we'll take a look at that case. Hello, my name is Nicholas Wansbetter. I'm a lawyer in Stratford, Ontario, Canada, and welcome to Don't Talk TV. So while I'm certainly not a family court lawyer, and I have no interest in ever doing family court, as I said in the preamble, a number of viewers and friends have sent me a very recent decision from the 22nd of February 2022 from a justice of the Superior Court of Justice ruling on a family court case. It was a case where a father was asking the court to order that his children be vaccinated, children who were under the primary care of their mother, who was the custodial parent. We've seen a lot of these cases happen recently, and usually the outcome has been that the courts have sided with the parent who wants the children ordered to be vaccinated. Now, that said, most of the cases where I've seen that happen has been cases where it's the non-custodial parent who's asking the court to order that the children not be vaccinated. So this is a bit of a different circumstance, but I want to look at the case not just because of the outcome, but because of some of the very excellent and poignant statements made by the judge in his decision, which I think are very important for everyone to hear and be reminded of some of the principles that he outlines. So the case is JN versus CG. It's a decision of Justice A. Pazarats. And right at the outset, Justice Pazarats opens with a bang with some very important questions that should be asked a lot more. When did it become illegal to ask questions, especially in the courtroom? And when did it become unfashionable for judges to receive answers, especially when children's lives are at stake? How did we lower our guard and let the words unacceptable beliefs get paired together? In a democracy? On the scales of justice? So should judges sit back as the concept of judicial notice gets hijacked from a rule of evidence to a substitute for evidence? And is misinformation even a real word? Or has it become a crass, self-serving tool to preempt scrutiny and discredit your opponent, to delegitimize questions and strategically avoid giving answers? Blanket denials are almost never acceptable in our adversarial system. Each party always has the onus to prove their case, and yet misinformation has crept into the court lexicon, a childish but sinister way of saying, "You're so wrong, I don't even have to explain why you're wrong." I really can't add much to what was said in those opening paragraphs, other than that I'm sure all viewers have seen this playing out, and as I've stated on this channel before, politics are downstream of culture, and the law is downstream of politics. So it's very clear where this is coming from. I mean, and the whole unacceptable views, that's obviously a reference to Prime Minister Justin Trudeau and his comment that people who disagree with him are a tiny fringe minority who hold unacceptable views, which is, as I said in the video where I was talking about whether that's hate crime or not, again, I don't think it meets the test of hate crime, but it's certainly a terrible thing for a prime minister of a supposedly liberal democracy to say. So let's get back into the decision where the judge links this to why this is important to family court. Paragraph 6 says, what does any of this have to do with family court? Sadly, these days it has everything to do with family court, because when society demonizes and punishes one who disagrees or even dares to ask really important questions, the resulting polarization, disrespect, and simmering anger can have devastating consequences for the mothers, fathers, and children I deal with on a daily basis. Paragraph 9, the motion before me is typical and frightening example of how far we are drifting from cherished values. The father wants 2 children ages 12 and 10 to receive COVID vaccinations. The mother is opposed. Now, answer honestly, did the previous paragraph give you enough information to form an opinion about how this case should turn out? Maybe not viewers of this channel, but I think a lot of people out there would have said, oh, well, obviously the mother's wrong, she's crazy, and she should have the children taken away from her. And we see these sort of attitudes, not just in the comments sections on news stories, but in the news stories themselves. As I've said before, it's a very scary time that we live in, so this case is very important, I think. Carrying on, at paragraph 14, This is so crucial, and this is something that I mentioned a number of times during my live stream. We have to rely on and insist upon evidence. The law is about evidence, not people's feelings, not what news articles report, not what our politicians falsely claim. Evidence. And the justice looks at the evidence. And it's important to note, he looks at what was the evidence that was presented to him. Paragraph 17, the mother's evidence focused entirely on the medical and scientific issues. In contrast, the father focused extensively on labeling and discrediting the mother as a person in a dismissive attempt to argue that her views aren't worthy of consideration. And I just noted at the bottom, one of the aspersions cast by the father on the mother was affiliations with the People's Party of Canada. And as the justice rightly points out, we're in deep trouble if belonging to a certain political party means you're going to lose the rights over your children. Page 6, there's more discussion of this, and I think very important. Paragraph 24, a chilling example of this bitterness and vilification, character assassination that's going on. The justice indicates, I recently had a case where a mother tried to cut off an equal time father's contact with his children, primarily because he was, quote, promoting anti-government beliefs, unquote. And in communist China, that request would likely have been granted. But this is Canada, and our judicial system has an obligation to keep it Canada. This is so fantastic to see a justice speaking what should be a very blatantly obvious truth, and has been for years. Now, I think it is important, though, to keep in mind the context of this case, and paragraph 30 starts a bit of discussion of that, where the justice agrees with the father that the two children are not old enough to decide the complicated issue for themselves, but disagrees with his suggestion that the court should simply ignore how they feel. Now, I discussed this in an earlier episode where we looked at that there is no minimum age at which there can be medical consent. There's a detailed analysis on the mature youth, whether that young person has the capacity to decide. So in this case, that was what was wrestled with by the justice. Now, it's interesting because a lot of the people who come to me saying that children shouldn't be allowed to decide are the ones not wanting their children to be vaccinated against the parents' will by the school. Here we have a father wanting children to be vaccinated against their will because of his views, and the judge is now using that doctrine of the mature youth to determine whether these young people actually know enough and, that he should take into account their views. And ultimately he does. Another important aspect of the case, paragraph 66, the justice refers to some other decisions about judicial notice being taken. This is very important because some justices have been taking judicial notice of just taking it for granted that what the government says about safe and effective is true and that there's no need for any evidence and it cannot be questioned. But in RSP and HLC, Justice Brighthop Smith recently set out a timely warning about the danger of applying judicial notice to cases where expert opinion is unclear or in dispute. It's a warning I wholeheartedly adopt. And quoting from that decision, says, unfortunately, the recent case of St. Fard and St. Fard does not assist in navigating medical treatment for minors because of its fatal flaw regarding judicial notice. In that case, the court wrote, facts may be found by taking judicial notice. Each of these cases include findings related to the safety and efficacy of publicly funded vaccines on the basis of judicial notice. End of quote. This shows a misunderstanding of the purpose of taking judicial notice, which, according to the Supreme Court's definitive decision in R.V. Find, is intended to avoid unnecessary litigation over facts that are clearly uncontroversial or beyond reasonable dispute. And just to put that in a bit of context, the Holocaust has been deemed to be something that the courts cannot take judicial notice of, and that's something that's been much more extensively researched than COVID-19 vaccines. There's a number of very good comments about judicial notice in the case. As always, I'll leave a link to the case in the show description below so you can look at it yourself. At the end of the day, the judge ordered that the mother would retain control and decision-making over whether the children receive a COVID-19 vaccine. Now, I think it's very important to note what was the expert evidence that the mother relied on in this case. With the greatest of respect, I know there's a lot of people that really respect people like Dr. Tenpenny. She didn't bring in people like that who are completely lacking in the right letters after their name. The mother in this case brought in information from Pfizer itself, as the judge said, well, it's Pfizer, the people who made this. Obviously, this isn't some crackpot conspiracy theory. I need to consider what they say. She brought in evidence from Dr. Malone, who invented mRNA technology. These are highly credentialed people, and it's always been my position that Those are the ones we need to rely on. If you want to argue over COVID-19 vaccines, it needs to be people like Dr. Malone, Dr. Bridle, Dr. Hodkinson, Dr. McCullough, people that have impeccable credentials that can't be attacked versus, I mean, Dr. Tenpenny, just as I don't mean to pick on her, but it's just a name I see come up a lot. She may well be 100% correct. I don't know because I'm not a medical doctor, but she's an osteopath. She's not an infectious disease specialist or a virologist or a professor who specializes in vaccines and immunology like Dr. Bridle. So you need to use the right experts, in my view. And a final note on this case is viewers may notice that the mother was self-represented. She did a very good job. It seems that she was a very reasonable person dealing with a very unreasonable person on the other side, and it worked well to her favor. However, I don't recommend that people go into court without counsel. In my view, this case doesn't stand for the proposition that lawyers are idiots, they're a waste of money, and you shouldn't hire them. I mean, obviously, I am a lawyer, I do my job for a reason, and I believe I provide a valuable service, but I don't think that's without merit to suggest that lawyers provide a valuable service. I mean, our whole job is knowing the law, constantly studying and updating on the law, which the average person doesn't have the time or ability to do. We have experience in court, advocacy, making legal arguments, in court procedure, when we're allowed to ask questions, what sorts of questions are able to be asked. So I think in general, a self-represented person going against a lawyer is going to be at a disadvantage. So I certainly don't recommend it, but kudos to this lady for the good job that she did in her own case in this instance. This video, of course, is not legal advice. If you need legal advice, you can call another lawyer or myself. My number is listed below, as well as my website. If there's show topics you'd like to see me cover, please send an email to the email address listed below or leave a comment in the comment section. And if you found this video at all interesting, helpful, or informative, please consider liking, sharing, and subscribing.